Well, good afternoon. Wow, this quiet room just got loud. We're going to begin this meeting of the General Government Subcommittee of Appropriations. We have 4 compensation resolutions to hear today. I will tell you all in advance that we really need to keep each of them to 15 minutes. We lose this room at 4 o'clock. So if the presentations could be around 10 minutes or less, so we have some time to ask questions and deliberate. And with that, Chairman Houston, excuse me. My roommate's Houston. I always screwed it up. But if you want to come up and present wherever you want. I'll allow Mr. Riley to do that, my good friend who I haven't seen in a while.
Riley's coming up, I'll start talking, so we've got to go fast, I know. This is just such a sad case to bring to y'all. I just hate to think that someone was really denied justice in the district that I represent. But Dante Inman was working at a Pizza Hut, lived in Adel, Georgia, and a girl from Pizza Hut was murdered, and he was accused of murder. And if you've read the transcript, you will see time and time again, this man was denied justice. And I know that there's no amount of money that can make up for all these years, but we need to do something to try to help him and get his life started back again. And while y'all doing this, you will see that the GBI withheld some evidence. The DA did things that were wrong. These people who do these injustices to people need to have some kind of punishment too. So while you're throwing out punishment, throw them out some. Thank you, and I'll let Tom tell you all about the case. Go ahead.
Mr. Chairman, honorable members of the committee, I'm Tom Riley with the law firm of Troutman Pepper Hamilton Sanders, and it's been our privilege to represent Devanya Inman in his habeas corpus petition over these last 6 or so years. And as Chair Lady Houston said, it's a tragic story, but one that has happily ended better than most. And certainly better than he could have expected a few years back. Mr. Inman was arrested and convicted for a homicide that he did not commit back in 1998. He spent 23 years incarcerated, and ultimately we were able to file a petition on his behalf in front of Judge Graham in Chattooga Superior Court, and she found after an evidentiary hearing that there were numerous errors of constitutional dimension in his trial, and that he was deprived his constitutional rights, and that his conviction was not worthy of any confidence. And so she granted our petition, and then the current district attorney in Cook County dismissed the charges, and Mr. Inman was released 2 days before Christmas in 2001. He's now living at home with his parents in Sacramento, California. He's got a job at FedEx, and that's the very first thing that he told me when he got out, was that he needed a job, and so I'm happy to report that he's pursued that. But we're here today on the recommendation of the Claims Advisory Board to compensate Mr. Inman for his wrongful conviction. As Chair Lady Houston referred to, there were unfortunately a number of state actors involved in the wrongful conviction. The GBI did give erroneous testimony at his trial that the man who ultimately whose DNA was found on a mask that was found in the murder victim's car, Hercules Brown, Mr. Inman's defense team at trial sought to introduce evidence that Hercules Brown was the real perpetrator of the crime. That evidence was excluded by the trial court, but there was exculpatory evidence. There was evidence that indicated Mr. Hercules Brown's involvement that was not disclosed by the prosecution to my client. There was testimony from the GBI that there was no indication that he was involved. There were repeated statements from the prosecutor that there was not one scintilla of evidence that Hercules Brown was involved. Ultimately, what happened was the Georgia Innocence Project got involved years after my client's conviction. They located a homemade ski mask that had been found in the victim's car. It was tested for DNA evidence, and it returned a match to Hercules Brown to a 1 in 18 quadrillion degree of scientific certainty that it was Hercules Brown's DNA on that mask that was found in the murdered victim's car and no one else's. So unfortunately, that evidence was not enough to get Mr. Inman a new trial. The trial judge denied his extraordinary motion for new trial at that time. The Georgia Supreme Court did not take the appeal at that time, but one of the extraordinary things that happened in this case is that during the course of our habeas proceeding, when the case went back up before the Georgia Supreme Court, then presiding Justice Namias said that this was essentially the most compelling case of innocence that he had seen. And he observed, I think, very accurately and correctly for this case, that everyone involved in the criminal justice system should dread the conviction and incarceration of innocent people. And that's what we're talking about here today. Our client was innocent of this crime. He had 23 of the best years of his life taken from him, and we certainly appreciate the indulgence of this committee and the consideration of our request for compensation for that wrongful conviction. We requested in our materials total compensation in the amount of $1.61 million for those 23 lost years. Understand that that is in the discretion of the committee, and we certainly welcome your entertainment of that amount and any amount that you see fit. And I'm happy to answer any questions. It's a very long and complicated case. It is a tragic case, as I said, but we do appreciate the consideration, and I'm happy to answer any questions you may have.
For the benefit of everybody, can you tell me the Claims Advisory Board, when they voted on this, how they voted?
Yes, Mr. Chairman. So in this case, the Claims Advisory Board voted unanimously 4-0 to recommend compensation in this case, and that is as a result of the claims that we asserted against the GBI. There were also claims asserted against the Department of Corrections, and that claim was bifurcated, and the suggestion of the Claims Advisory Board was to deny payment on that claim. But for the GBI claim, it was a 4-0 vote in favor of compensation.
Any questions from members of the committee? Chairman Parsons?
Yeah, I don't guess we're using these things here, but
I got you lit up if you need
I got
it.
a few minutes late, but I just want to ask you, I remember these things before that we've had. I know that he's been in prison, he's not in prison anymore.
Yes, please.
So the gentleman was convicted, he was in prison, he's not in prison now, he lives in California. As I recall, there's some kind of I'm not an attorney, but I remember there's some kind of a Latin term, I think it's a Latin term, that actually is used when the court actually says that he has been exonerated, he's no longer before the court. I mean, I didn't see that looking through here. What's the status of his conviction?
The conviction has been overturned and expunged from his record. The petition that we filed was called a petition for habeas corpus, and that is what the Chattooga County Court granted.
Okay. I mean, that's all. I just remember we had some of those first ones, if you remember. You were on this committee. Yeah. You were on this subcommittee. And I just remember that some term, which I don't know, I wouldn't know what it meant, but it was just it wasn't English. It was some kind of a Latin term, I think, that they used.
You're very welcome.
Chairman Smith?
Thank you, and thank you for your presentation, and Representative Houston as well. I'm on the last page of the bill, page 6, and since this is an Appropriations Committee, I'm just curious as to how the appropriations arrived at the number of essentially 1.6 million.
Certainly. So that number was derived based on $70,000 per year for each year of wrongful conviction. It's actually a little bit more than 23 years, but we just used 23 years times that $70,000 number to arrive at that $1.61 million figure. And then, as you can see, the legislation proposes an initial payment followed by the balance being paid into an interest-bearing annuity account. And obviously, being in the inflationary environment that we're in, simply paying out the face value of the dollars is not going to give the full intended benefit over time, given the current economic situation.
And one further question. So your basis for your multiplier was 70,000 per year, and that was derived at how? The 70?
So the 70 was derived at basically looking at the prior history of compensation legislation, also looking at how these compensation requests are dealt with around the country, and there are numbers all over the map. But we feel that it is, we based it on what's happened in the past, and then taking into account the current situation and the circumstances of this extraordinary case.
Thank you for that.
Certainly.
Chairman Prince.
And I agree to that, Chairman Houston. Yeah, thank you, Mr. Riley. And just piggybacking off of Chairman Smith's question, did this amount, did it take into any account any payments, for lack of better words, or fines that he had to pay, i.e. trying to defend himself from one, or any fines or anything like that?
It did not. It did not. And our representation of Mr. Inman was pro bono, so our firm did not charge him for our services. We did have about 35 to 40 people affiliated with our firm work over the course of about 5.5 or 6 years, but there was no charge for our services.
Not for ourselves, but for others.
Exactly. Exactly, Representative Prince.
Seeing no more questions, I'll advise the committee where the posture that we're in. We're going to hear each of these. We will then take action on them at the end. We will be in a position of debating the amount and the appropriateness of moving forward with any of these resolutions. So at this time, I think we're going to move on to the next one.
Thank you.
Thank you, Mr. Riley. Yes, ma'am. Come on down.
Thank you, ladies and gentlemen of the committee. Shall I begin? During the last redistricting of my district, I was drawn into Troup County and LaGrange, and we're going to talk about that community today. And so 42 years ago, there were events that led to my now new constituent being wrongfully convicted and ultimately imprisoned for the better part of his life. Evidence was found by a joint re-investigation by the LaGrange Police Department, the Coweta Judicial Circuit DA's office, and the Georgia Innocence Project to prove that Mr. Terry Talley was innocent of crimes. And Ms. Gilbert here with the Innocence Project will be here to answer questions and give more details in just a minute. But I just wanted you to know that while I was up there meeting people, I had the opportunity to talk to Police Chief, LaGrange Police Chief Deckmar, and he shared with me that during the reinvestigation of this court that they found that Mr. Talley was convicted on unreliable evidence, that the LaGrange Police Department had failed to investigate viable alternative suspects that they were aware of at the time of the crimes occurring, and that almost all of the physical and biological evidence from the original investigation had been lost or destroyed, some of it back at the time of the crime in 1981. But most importantly was that the DNA had proved that he was excluded as the person who had committed the crime. After meeting Mr. Talley, I learned a lot about him personally, and it became clear to me that he, in his own words, he says he's a simple man. He never did finish high school. He has worked most of his life when he was out as a day worker, picking up odd jobs here and there in LaGrange. And he now works for the County Humane Society, where he helps take care of the animals, and has befriended a cat there that is no longer allowed to be adopted. It's Tally's cat, and he talks very proudly about that. He got the job in an effort to show that he was a functioning member of society and wanted to fit in. I met some of his co-workers and his supervisor, and they all have real positive reviews of his work ethic and gentle nature. And he seems to hold no ill will towards anyone for anything. He was exonerated for 25 years and 9.7 months that he served, and is seeking compensation for that. And he's been exonerated. The legal system has said and demonstrated that he was innocent, and that's pretty extraordinarily difficult to get an exoneration like that. And so at this point, I will let you tell what you need to tell, and I'll be available if there are any questions that I can answer. But thank you for your consideration.
Good afternoon, Chairman and honorable members of the committee. My name is Claire Gilbert. I am the former executive director of the Georgia Innocence Project, which is a nonprofit organization, independent, based here in Georgia, that works to prevent and correct the conviction of innocent people for crimes that they did not commit. During the course of my tenure at Georgia Innocence Project, I became familiar with Terry Talley's case, and then eventually with Mr. Talley himself. So I have volunteered to assist him in these efforts. On behalf of Mr. Talley, we respectfully request that the legislature compensate him in the amount of $1.808 million for the 9,431 days he spent in prison on crimes that he did not commit. Mr. Talley was convicted of several rape and sexual assault cases in 1981 LaGrange, Georgia, based on the theory that he was a serial rapist. Following a multi-year-long investigation and reinvestigation of the case, as Representative Buckner has explained, lots of new evidence came to light, including DNA evidence of innocence in one of the cases. Mr. Talley was exonerated with cooperation and support by the LaGrange Police Department and the Coweta Judicial Circuit District Attorney's Office, and 4 separate charges were dismissed, vacated, dismissed, and he was exonerated on those, which led to his freedom. The factual basis of the exonerations have already been reviewed by the police and the courts and the prosecutor's office, and most recently the Georgia Claims Advisory Board. So I'm just going to touch on them briefly, and if you have any questions about anything, just let me know. So this all occurred in the spring and winter and spring of 1981 in LaGrange, Georgia, and there were a number of sexual assault, brutally violent sexual assaults and aggravated assaults that were taking place on and around the LaGrange campus. Because the crimes were committed in a very similar manner, involving a reported black man who was attacking people from behind, choking, threats, blindfolding the victims with pillowcase, and then violently assaulting them. Police were, because of the similar MO, police were looking for a single perpetrator. In July 1981, Mr. Talley, who was an indigent, young black man who had made it through the 6th grade in school, came to police attention based on an unrelated incident. And when they started questioning him about the serial rapes, he vehemently denied any involvement in those. Yet, despite the lack of evidence, the police started calling witnesses in and subjecting them to identification procedures, which we now know in hindsight, and probably knew then, that they were very unreliable. One victim did not identify Mr. Talley at all. Another identified him only after seeing him in the paper. Another said she could only identify him by his voice and could not identify him in court, even though he sat close to her. And another victim said she was confident in her voice identification, very confident, because she'd heard him on the phone as well and that he had good diction. Police tested fingerprints on a threatening note left on a victim's car, and the fingerprints did not come back to Terry Talley. They found no evidence that Terry Talley had ever called any of the victims, though the perpetrator called several victims. And yet police continued in their pursuit of him as the suspect. He decided to fight the cases because he was innocent and went to trial 4 months later. The first trial lasted 1 day. He was found guilty and sentenced to life in prison plus 10 years. The second trial took place the very next day, drew from the same jury pool. He was sentenced to life in prison plus 10 years. At this point, completely devastated that the judicial system is not working in favor of an innocent man, he followed the advice of his attorney and pled to the remaining charges, which did not add any additional time because they all ran concurrently. Decades later, after the Georgia Innocence Project got created and formed, we took on his case and began reinvestigating. By that time, almost all of the physical evidence had been destroyed in the case or lost, but we did manage to find one rape kit from one of the trials, and that was the one that Representative Buckner talked about. That was the case where the victim had been very confident in his voice. The DNA testing on the male sperm cell fraction in that case came back to exonerate Mr. Talley and prove that he was not the perpetrator. And it also created the thread through which we were able to unwind the other connected cases. Advances in the course of reinvestigating the case in conjunction with the police department on and off over the years. We secured the DNA testing, as well as we are now aware of advances in eyewitness identification procedures that show how flawed these were, and they probably wouldn't even be admissible in court nowadays in Georgia with the new statute. Additionally, there were significant Brady violations and misconduct that occurred throughout this case. In one of the trials, the victim testified. Police bolstered her testimony, saying that there was no reason to doubt her credibility, that victims of sexual assault often tell the truth, and yet they hid evidence that at the time of the crime she had a 0.34 blood alcohol concentration, which is over 3 times the legal limit, and would significantly impair her ability not only to recall memory, but to form it in the first place. It also turned out that there was an alternate suspect that had been developed by the police that was not investigated fully. It was that was not revealed to the defense, and it was a city attorney. And rather than investigating, it wasn't a city attorney; it was a city employee. And rather than fully investigating the case, they just turned a blind eye and let the employee go, and did not reveal the relevant information to either the prosecutor or to the defense, it appears. And finally, it turns out that at one of the trials where the victim had claimed to identify Mr. Talley by voice, it was not revealed prior to trial that she had previously identified a different suspect. So when all of that information came to light, we were able to partner with the police department in presenting it to the DA's office, who very quickly jumped on it, worked to vacate and dismiss the convictions, and Mr. Talley is free today. This is the basis for our compensation. If you'd like, I can explain how we get to $70,000. We also worked on that number as well. We have the same request, $70,000 a year, and the Claims Advisory Board in this case recommended against compensation for the Department of Corrections. That's the one the claim was against. But they did write a note in their report that Mr. Talley presented compelling evidence that he was wrongfully convicted in all 4 cases, and that his requested compensation amount, quote, while admittedly far short of the actual loss of being held in prison for over 26 years for crimes he did not commit, is in line with how other states and the federal government compensate wrongfully convicted persons. And I think that's about it, but I'm happy to answer any questions.
Okay, Chairman Parsons.
Thank you, Chairman. Thank you for the presentation. Now, first of all, I'll just say, the way I've always looked at these for myself as a member of this subcommittee is that, if we're presented with the information that shows that they were wrongfully convicted, then it's up to us then to decide how much, if anything, that they need to be compensated for, not to retry. I mean, and I found the information. I found the phrase in here in your resolution 61 through 63. I guess my question is it not true that language there that the court signed a consent order vacating convictions and granting the motion to enter, I don't know how you pronounce it, nolle prosequi? That is,
we call it a nolle pros.
Okay. That is actually, that is the line there that actually shows that he was, according to the state of Georgia, wrongfully convicted and released, and that conviction was vacated. Is that not true?
Correct. The conviction is vacated, and then the underlying indictment remains. The prosecutor has an option at that time to either retry the case, urge a plea, or dismiss the underlying indictment. And in these cases, the prosecutor chose to dismiss the underlying indictment in all 4 cases.
Thank you. That was my question.
Any questions from the committee? All right. Thank you.
Thank you.
Representative Evans, if you'll tell us which one I know that you have 2, irrelevant to us which one you start with, just let us know so we're following along appropriately.
Thank you, Mr. Chairman, members of the committee. Let's start with House Resolution 48, Mario Stinchcomb, but they are related, same incident, 2 gentlemen.
Thank you.
So thank you, Chairman, members of the committee. Presenting House Resolution 48, which is a compensation resolution for Mario Stinchcomb. Mr. Stinchcomb, along with Mr. Woolfolk, who we'll talk about in the next resolution, were the first 2, and Mario being the first to be exonerated through the Fulton Integrity Unit. So it's a really big deal. It's been a great thing for Fulton County to go back and figure out where they got it wrong, and this is one where they did. So what happened in this situation is that Mr. Stinchcomb shot in self-defense. He was with Mr. Woolfolk. They were at a house. The decedent was shooting at them from a car, toward them and also toward the home where they were. In self-defense, they went to get weapons. At this point, the decedent was shooting into their home. So they were sort of ducked behind a window shooting back. So they weren't aiming at anyone. They were simply trying to keep themselves safe. And one of the bullets, of course, hit the decedent, and she died. It was thought she had someone in the car with her who ultimately provided the testimony that supported the statement from Mr. Stinchcomb and his co-defendant, which was their story from the very beginning. It was consistent the whole time that they were acting in self-defense. The physical evidence always supported that story, but they were under the mistaken belief that the eyewitness that was in the car with the decedent was dead. And that turned out not to be true. And when that person was found, they were able to come provide their testimony, which corroborated, again, the story from Mr. Stinchcomb and his co-defendant from the beginning, always consistent that they were acting in self-defense. And again, the physical evidence supported their testimony. And it took way too long for them to get their motion for new trial before the Superior Court. The Supreme Court was very upset about that and issued an order ultimately giving them that option, and then ultimately it ended up in a null pros because the prosecution realized that they had no case because indeed it was self-defense. And so for this wrongful conviction, we asked for Mr. Stinchcomb to have the compensation set forth in House Resolution 48, which is consistent with how we've done it in the past. And I'll stand for any questions.
Representative Stoner.
Thank you, Mr. Chairman. I was looking at, how long did they serve?
18 years.
18 years?
Looking at my 18, yes.
Okay,
18 years.
thank you.
And Mr. Stinchcomb in particular, missing 2 children grow up and several family members that passed away. And his girlfriend, who they were both devoted to each other at the time, of course moved on in those 18 years. And Mr. Stinchcomb is now driving a truck and has reunited with the girlfriend, though. But 18 years is a long time in the prime of life.
I ask one quick question. Obviously, the eyewitness being coming back was a huge catalyst for that. Was there can you speak to any other evidence or what they used against them to convict them of this?
Well, there was another eyewitness whose testimony was always inconsistent. It changed many times throughout, but he was the one who placed blame with Mr. Stinchcomb and Mr. Woolfolk, and that was essentially the basis of the conviction.
So no physical evidence that they used against them for any wrong?
No, the physical evidence always supported their testimony of self-defense.
Any other members' questions? Representative, you can speak to the next one. Obviously, it'll be this. Oh, I'm sorry. I apologize. Floor leader.
What was the recommendation of the commission on this?
So the recommendation of the commission was to deny, but not based on the facts or any belief that these gentlemen were not in fact innocent and worthy of being exonerated, but simply that there was no fault on the part of the penal system, because clearly they were not the ones that put these gentlemen away.
Any other questions? All right. Now we can move on to the next.
Thank you, Mr. Chairman. Next would be House Resolution 49, which is a compensation resolution for Michael Woolfolk, who was the co-defendant. Same facts, same situation, just unfortunately a different tragic life lost for 18 years in the prison system in the prime of life. Loss on wages in life and all the things that we all enjoy. And Mr. Woolfolk also is driving a truck now and is doing well and has the support of family and friends. And I'd be happy to stand for questions, but it is, I don't want to go through it again. It's exactly the same.
Chairman Prince.
Thank you, Mr. Chairman. Representative Evans, can we explain why the, I guess the amount is different if they were?
So Mr. Stinchcomb's is slightly lower than Mr. Woolfolk, and thank you for bringing that to the attention of the committee. The reason is that it's not, we're not 100% sure, but the belief is that Mr. Stinchcomb probably should not have been in the possession of a firearm, even though if you're not legally able to carry a gun, you certainly are still able to self-defend yourself with a gun. It's just that he shouldn't have been possessing it, and in fairness to the belief that there should be some consequence for the potential illegal possession of the gun, we discounted it by 5 years.
Was he charged with illegally carrying a weapon?
No. Oh, he was, I'm sorry.
He was.
First mistake I've ever made. Sorry.
Can she clarify?
Please come up and introduce yourself for everybody, please.
Sorry. My name's Lee Schroep, and I represented Mr. Stinchcomb through this and have been assisting Mr. Woolfolk. Mr. Stinchcomb, when the district attorney agreed that they were acting in self-defense, had concerns about him holding a gun. We discussed we could fight that because it was self-defense, but he ultimately made the decision that he wanted out of prison. It was the middle of the pandemic, so he agreed. She no-prossed all the murder charges, but he did take a plea to having that gun, which was the 5 years, which is why we discounted it 5 years from what we asked for Mr. Woolfolk. And just one clarification, not that it matters, it was Mr. Woolfolk was actually the one who fired the fatal shot, not Mr. Stinchcomb, but they were together.
And I think both of them unaware of where the bullets were flying, yes.
What did you add? I'm sorry.
Just that neither one of them were aiming for him. They were unaware of where the bullets were hitting.
Chairman Smith?
We were trying to clarify something, but I'm not sure what we're quite clarifying. One question is for both of them, what was the basis for denying House Resolution 48 and House Resolution 49 by the Claims Advisory?
By the Claims Advisory Board, that the penal system did not have any fault in their wrongful incarceration, in their being incarcerated. But the board expressed concern, may not be the right word, but acknowledged that that they were exonerated and they were wrongfully imprisoned. But that wasn't something the penal system did, so they didn't feel like it was in their authority to make a compensation award. I might submit for this committee or other wonderful legislators in the future, we might think about providing the board with more extensive authority to award these compensation resolutions.
Thank you, Chair, that's my confusion here, trying to be the judge right now without enough information.
And I would just emphasize again, Chairman Smith and members of the committee, that this went through the Georgia Supreme Court and the Superior Court system and the Fulton Integrity Unit, who all agreed that this never should have happened, and they were fully exonerated.
Any other questions? All right, thank you.
Thank you.
All right, members of the committee, it's now we've got to take action on each of these. I feel like these are always uncomfortable because clearly, like Representative Evans just said, they've gone through the process of being exonerated. So in that sense, we're not being the judge and jury, right? They're out of jail. Thankfully, they've returned to their lives. Unfortunately, we get put in a place of determining whether or not these dollars should be allocated for their time lost. And I feel like it puts us in a uncomfortable position because we're representing the state. And the way I tend to look at these is whether or not the state was at fault. And that's, I believe, obviously what the Claims Advisory Board also looks at when they're determining these things. We also have to determine, there's some material, I believe that are in your packets that speak to how some of the other states around us. I'm sorry. That's just mine. I'm sorry. I apologize. I have more information right here that I will be glad to share with you. If you'll give me a moment. It's the last page of this, isn't it? I just saw it. I apologize. Look at that one if you want. Go back one page. That's it. Thank you. Just to give the committees a little more information, federally, the statutory award amount for wrongful convictions is $50,000 a year. Alabama, Florida, Mississippi, North Carolina, all each are also $50,000. Their years vary on when those award amounts were adopted, and this document would suggest obviously amount adjusted for inflation from those numbers when they were adopted to 2022. They range from 69,000 up to 84, depending on obviously when they were adopted. So that gives you a little information on how some of the other states view the compensations and where they would be adjusted for if you're adjusting for inflation. So that's the posture that we are in, and again, we need to take these one at a time. So if there's any discussion, let's start with, we're starting with House Resolution, make sure I get the right number so everybody, 7-0, LC 442207. Floor Leader Gamble.
Mr. Chairman, I appreciate, I have a couple questions that are more generic in nature, not specific to any one of these particular resolutions, because I am new to the committee, and I apologize. I should have just spent some time on the internet looking this up before we got to committee, but the Claims Advisory Board, are those positions appointed by the governor, or who appoints the members of the Claims Advisory Board?
Yeah, it's
Secretary of State, Department of Transportation, Department of Corrections, and Human Resources, I believe. Yes.
Yep.
Secretary of State, Commissioner of the Department of Human Resources, Department of Transportation, Department of Corrections, or their designees. In this case, I think they're designees. Okay. And then as far as the resolutions go, I know that Legislative Council drafts these, but the actual information that they use for these resolutions, does that come from the court records for these cases and just basically summarized for our use in the form of a resolution?
That would be an accurate assessment.
Okay. And then the annuities that go along with each of these settlements, if we do approve them, are those annuities sold? I guess does the state, how do they purchase the annuity, I guess, or structure that?
Here, I'm going to let you answer that. That's a lot of words.
The Department of Administrative Services will handle it. They will seek, or rather reach out to.
Do they put an RFP out for that or something?
Sort of. They have a couple of vendors I think they already have identified and have used in recent years. And then they will provide a final estimate on the cost based on the award amounts.
Okay. Thank you. That just clarifies a few things for me.
All right, so we're looking at, again, HR 70. What's the will of the committee?
Based on the Claims Advisory Board of a 4-0 decision, I recommend a do pass for this one.
Do I hear a second?
Second.
Chairman Smith recommended do pass based on the Claims Advisory Board's vote of 4-0. We've had a motion and a second. All in favor, say aye. Aye. All opposed, like sign. HR 70 passes. Moving on to HR 55. Mr. Talley?
I have a question related to the past history of this panel. What is their percentage of passing the resolutions based on what? Is there a guideline? I mean, are they always all passed? Is it, or is there debate, or
I think there's, and I'll speak somewhat out of turn and not having extensive knowledge of their overall history, but based on the documents that I've read, I mean, they obviously thoroughly vet this, and again, they're trying to determine whether or not the state is responsible. And like we've heard in one of these cases, they felt like the state was, and the others they did not.
And I certainly appreciate the case by case. I just know not having the availability of how other panels debated the issues is a little bit more difficult this time.
Yeah.
Thank you, Chairman. I think, like was said before, there's really no way you can put, there's no way you can not put a figure on the time that these people spent in prison. I mean, there really isn't. The only thing I would say is, and I do remember that we took these up, and you ladies were on that subcommittee at that time. We were pretty, I know the three of us were on that subcommittee when we had those first ones that came to us as these things are now set up. And I think the first one we did, and that would have been in about 2006, something like that, was for, I want to say that one was for $1 million. I think how much it was. That's just how much it was, I don't know whether that was the recommendation or we came up with it in the subcommittee. That I don't remember. It's been several years ago. I mean, from my recollection, this is, well, just looking at this one here right now, we got 55, I think, in front of us. It seems to me it's in line with what we've done before. And, and obviously, you had a good question, but I don't think we can say we have 4 in front of us, so, well, we probably ought to do 2 of them or whatever. I know that's not what you meant. But I think they're probably pretty much in line with what we've done before, and there is no way to really come up. What's a year in a person's life worth? I don't, it just seems to me that these are in line with what, or at least I'm just talking about the one that's in front of us now, which I think is 55, but I think it's in line with what we've done before. I guess that's my input in that.
Thank you, Mr. Chairman.
Yeah, I'd like to reiterate, I think we all are going to agree on the fact that there's no way to put a number on this. And again, we get put in the unfortunate position of knowing whether or not, or determining whether or not we feel as though the state is at fault and should be paying this. I'm going to allow 1 minute, because I do think it will be helpful, but we need to move on. So if you'd like to real quickly tell us what you're trying to address.
Sure. As part of my work with the Georgia Innocence Project, I've reviewed these claims going way back, including the 2006 one. This is actually the first year that the Claims Advisory Board has ever recommended payment on a claim, and that was because it was against the GBI. Most of the time, the claims are brought against the Department of Corrections because of limitations with what you can do with the Claims Advisory Board. And in the recommendation from the Claims Advisory Board, the last sentence that I didn't read, that I should have read because I read the preceding sentences, says, "The General Assembly, in its discretion, may elect to consider evidence beyond simply the culpability of the state agency that the claim is filed against," meaning you can go ahead, just because the Claims Advisory Board recommends denial of the claim against the Department of Corrections when the claim is against like a city entity or something like that, you are able to go ahead and award. This committee has denied claims in the past and also has recommended many claims proceed despite recommendation from the Claims Advisory Board in line with what we see today.
Thank you for some clarification there. Representative Stoner.
Thank you, Mr. Chairman. To the point she was making when I served in the Senate, and the point you're making is that on occasion we would actually go, the board would say no, and we would say yes at different times. So to illustrate that point, that was done. Not in every case, but actually a lot more. Because again, how do you put any time? How do you figure out what the value of that is to someone's life and everything? So that sometimes, even though legally speaking, it wasn't the corrections, it wasn't the, they're not the folks that got convicted. At the end of the day, the whole structure of what we've set up in the state from a legal standpoint is the state. Even if it's a local DA or whatever, that is created by us, the General Assembly. That's part of our Constitution and what we do. So at the end of the day, I always look at this, it might have been the local prosecutors, it wasn't the correction system, but we ultimately are the ones who create that system, and we ultimately have responsibility for how that system operates at times. That's always been my view, but anyway.
We will forgive your service in the Senate, but that's a whole nother matter we can take up another day. HR 55, what is the pleasure?
Make a motion. Do pass. I do pass.
I hear a motion do pass and a second. All in favor say aye. Aye. All opposed? Motion passes. All right. Yeah, let's go with HR 48. Mr. Stinchcomb. Any discussion?
Second.
Hear a motion and a second. All in favor?
Aye.
All opposed? Motion passes. HR 49. Hear a motion?
Second.
I hear a second. All in favor, say aye.
Aye.
All opposed, like sign. Motion passes. We will adjourn this meeting. Thank you.